Lea greater than U.S. Supreme Court greater than Jesinoski v. Countrywide Home Loans, INC. Jesinoski v. Countrywide Home Loans, INC. Syllabus Jesinoski v. Countrywide Home Loans, INC. 729 F3D 1092, reversed and remanded. Syllabus PDF Opinion, Scalia Opinion PDF. Note: where it is feasible, a syllabus headnote will be released, as is being done in connection with this case, at the time the opinion is issued. The syllabus constitutes no part of the opinion of the court but has been prepared by the reporter of decisions for the convenience of the reader. See United States v. Detroit Timber and Lumber Company, 200 U.S. 321, 337. Supreme Court of the United States. Syllabus. Jesinoski et al. v. Countrywide Home Loans, Inc., et al. Certiorari to the United States Court of Appeals for the Eighth Circuit. Number 13 to 684. Argued November 4, 2014. Decided January 13, 2015. Supreme Court. Exactly 3 years after borrowing money from respondent Countrywide Home Loans, Inc., to refinance their home mortgage, petitioners Larry and Cheryl Jesinoski sent Countrywide and respondent Bank of America Home Loans, which had acquired Countrywide, a letter purporting to rescind the transaction. Bank of America replied, refusing to acknowledge the rescission's validity. 1 year and 1 day later, the Jesinoskis filed suit in federal court, seeking a declaration of rescission and damages. The district court entered judgment on the pleadings for respondents, concluding that a borrower can exercise the Truth in Lending Act's right to rescind a loan, C. 15 U.S. C. Section 1635 A.F. only by filing a lawsuit within 3 years of the date the loan was consummated. The Jesinoskis' complaint, filed 4 years and 1 day after the loan's consummation, was ineffective. The Eighth Circuit held, a borrower exercising his right to rescind under the Act need only provide written notice to his lender within the 3-year period, not file suit within that period. Section 1635 A.'s unequivocal terms, a borrower shall have the right to rescind, by notifying the creditor of his intention to do so. Emphasis added, leave no doubt that rescission is effected when the borrower notifies the creditor of his intention to rescind. This conclusion is not altered by Section 1635 F, which states when the right to rescind must be exercised, but says nothing about how that right is exercised. Nor does Section 1635 G, which states that, in addition to rescission, the court may award relief, not relating to the right to rescind, support respondents' view that rescission is necessarily a consequence of judicial action. And the fact that the Act modified the common law condition precedent to rescission at law, see Section 1635 B, hardly implies that the Act thereby codified rescission in equity. pp. 2-5. 729 F3D 1092, reversed and remanded. Scalia, J., delivered the opinion for a unanimous court. Top. Opinion. Notice. This opinion is subject to formal revision before publication in the preliminary print of the United States reports. Readers are requested to notify the Reporter of Decisions, Supreme Court of the United States, Washington, D.C. 20543, of any typographical or other formal errors, in order that corrections may be made before the preliminary print goes to press. Supreme Court of the United States. Blank. Number 13 to 684. Blank. Larry D. Jesinoski, et al., Petitioners v. Countrywide Home Loans, INC, et al. On writ of certiorari to the United States Court of Appeals for the Eighth Circuit. January 13, 2015, Justice Scalia delivered the opinion of the court. The Truth in Lending Act gives borrowers the right to rescind certain loans for up to 3 years after the transaction is consummated. The question presented is whether a borrower exercises this right by providing written notice to his lender, or whether he must also file a lawsuit before the 3-year period elapses. On February 23, 2007, petitioners Larry and Cheryl Jesinoski refinanced the mortgage on their home by borrowing $611,000 from respondent Countrywide Home Loans, Inc. Exactly 3 years later, on February 23, 2010, the Jesinoskis mailed respondents a letter purporting to rescind the loan. Respondent Bank of America Home Loans replied on March 12, 2010, refusing to acknowledge the validity of the rescission. On February 24, 2011, the Jesinoskis filed suit in federal district court seeking a declaration of rescission and damages. Respondents moved for judgment on the pleadings, which the district court granted. The court concluded that the act requires a borrower seeking rescission to file a lawsuit within 3 years of the transaction's consummation. Although the Jesinoskis notified respondents of their intention to rescind within that time, they did not file their first complaint until 4 years and 1 day after the loan's consummation. 2012 WL 1,365,751, *3 D Min. April 19, 2012, the Eighth Circuit affirmed, 729 F3D 1092, 1093, 2013, per curiam. Congress passed the Truth in Lending Act, 82 Stat. 146, as amended, to help consumers avoid the uninformed use of credit, and to protect the consumer against inaccurate and unfair credit billing. 15 U.S. C. Section 1601 A. To this end, the Act grants borrowers the right to rescind a loan until midnight of the third business day following the consummation of the transaction or the delivery of the disclosures required by the Act, whichever is later, by notifying the creditor, in accordance with regulations of the Federal Reserve Board, of his intention to do so. Section 1635, a 2006 ed. This regime grants borrowers an unconditional right to rescind for 3 days, after which they may rescind only if the lender failed to satisfy the Act's disclosure requirements. But this conditional right to rescind does not last forever. Even if a lender never makes the required disclosures, the right of rescission shall expire 3 years after the date of consummation of the transaction or upon the sale of the property, whichever comes first. Section 1635 F. The Eighth Circuit's affirmance in the present case rested 1. Upon its holding in Kieran v. Home Capital, Inc., 720 F3D 721, 727-728, 2013, that, unless a borrower has filed a suit for rescission within 3 years of the transaction's consummation, Section 1635 F extinguishes the right to rescind and bars relief. That was error. Section 1635 A explains in unequivocal terms how the right to rescind is to be exercised. It provides that a borrower shall have the right to rescind, by notifying the creditor, in accordance with regulations of the board, of his intention to do so, emphasis added. The language leaves no doubt that rescission is effected when the borrower notifies the creditor of his intention to rescind. It follows that, so long as the borrower notifies within 3 years after the transaction is consummated, his rescission is timely. The statute does not also require him to sue within 3 years. Nothing in Section 1635 F changes this conclusion. Although Section 1635 F tells us when the right to rescind must be exercised, it says nothing about how that right is exercised. Our observation in Beach vs. Ocwen Fed. Bank, 523 U.S. 410, 417, 1998, that Section 1635 F govern s. The life of the underlying right, is beside the point. That case concerned a borrower's attempt to rescind in the course of a foreclosure proceeding initiated 6 years after the loan's consummation. We concluded only that there was no federal right to rescind, defensively or otherwise, after the 3-year period of Section 1635 F has run, id. at 419, not that there was no rescission until a suit is filed. Respondents do not dispute that Section 1635 requires only written notice of rescission. Indeed, they concede that written notice suffices to rescind a loan within the first 3 days after the transaction is consummated. They further concede that written notice suffices after that period if the parties agree that the lender failed to make the required disclosures. Respondents argue, however, that if the parties dispute the adequacy of the disclosures, and thus the continued availability of the right to rescind, then written notice does not suffice. Section 1635 nowhere suggests a distinction between disputed and undisputed rescissions, much less that a lawsuit would be required for the latter. In an effort to sidestep this problem, respondents point to a neighboring provision, Section 1635G, which they believe provides support for their interpretation of the Act. Section 1635G states merely that, in any action in which it is determined that a creditor has violated this section, in addition to rescission, the court may award relief under Section 1640 of this title for violations of this subchapter not relating to the right to rescind. Respondents argue that the phrase, award relief, in addition to rescission, confirms that rescission is a consequence of judicial action. But the fact that it can be a consequence of judicial action when Section 1635G is triggered in no way suggests that it can only follow from such action. The Act contemplates various situations in which the question of a lender's compliance with the Act's disclosure requirements may arise in a lawsuit. For example, a lender's foreclosure action in which the borrower raises inadequate disclosure as an affirmative defense. Section 1635G makes clear that a court may not only award rescission and thereby relieve the borrower of his financial obligation to the lender, but may also grant any of the remedies available under Section 1640, including statutory damages. It has no bearing upon whether and how borrower rescission under Section 1635 may occur. Finally, respondents invoke the common law. It is true that rescission traditionally required either that the rescinding party return what he received before a rescission could be effected, rescission at law, or else that a court affirmatively decree rescission, rescission in equity. 2d. Dobbs, Law of Remedies Section 9.3, 3 pp 585 to 586, 2d ed. 1993. It is also true that the Act disclaims the common law condition precedent to rescission at law that the borrower tender the proceeds received under the transaction. 15 U.S. C. Section 1635b, but the negation of rescission at law's tender requirement hardly implies that the Act codifies rescission in equity. Nothing in our jurisprudence, and no tool of statutory interpretation, requires that a congressional act must be construed as implementing its closest common law analog. Cf. Astoria Fed, Save, and Loan Association v. Solimino, 501 U.S. 104, 108 to 109, 1991. The clear import of Section 1635a is that a borrower need only provide written notice to a lender in order to exercise his right to rescind. To the extent Section 1635b alters the traditional process for unwinding such a unilaterally rescinded transaction, this is simply a case in which statutory law modifies common law practice. The Jesinoskis mailed respondents written notice of their intention to rescind within 3 years of their loan's consummation. Because this is all that a borrower must do in order to exercise his right to rescind under the Act, the court below erred in dismissing the complaint. Accordingly, we reverse the judgment of the Eighth Circuit and remand the case for further proceedings consistent with this opinion. It is so ordered. Notes 1. Following the events in this case, Congress transferred the author ITY to promulgate rules implementing the Act to the Consumer Finance Protection Bureau. See Dodd-Frank Wall Street Reform and Consumer Protection Act, Sections 1061b, 1, 1100a, 2, 1100h, 124 Stat. 2036, 2107, 2113. Scoop Soldiers reporting for duty open.